Boa tarde, sejam bem-vindos à conferência digital Litigation, Mercado Português e Third Party Funding, uma iniciativa do Negócios em parceria com a CMS e a PLA, a quem agradeço o apoio. O financiamento de litígios por terceiros é uma prática pouco conhecida em Portugal, mas que já existe há vários anos noutros países, como os Estados Unidos, a Inglaterra ou o Brasil. No contexto da pandemia e da crise económica por ela provocada, esta é uma opção que deverá ganhar força. Já constitui uma alternativa para as empresas que não tenham o capital necessário para avançar com um processo judicial ou de arbitragem. Ao longo da próxima hora e meia, vamos debater as vantagens e desvantagens do financiamento de litígios por terceiros para os clientes e o sistema judicial. Contribui ou não para aumentar a litigiosidade? Torna ou não o processo mais eficiente e rápido? Vamos também falar sobre o papel dos vários intervenientes, os financiadores, as sociedades de advogados e os clientes, e a forma como o Third Party Funding pode ser aplicado em Portugal. Para debater estas questões, vou ter comigo Miguel Esperança Pina, sócio da CMS Portugal, Luís Andrade Pinhel, General Counsel para Portugal da PLA, Procurator Litigation Advisors, Robin Wood, associado sénior da CMS UK, Jesus Rodrigo Lavilha, CEO da PLA, e Manuela Costa, sócio especialista em litigância da CMS. Fará já a seguir uma apresentação com enquadramento sobre o Third Party Funding. Uma vez que temos um painel com diferentes nacionalidades, irei conduzir o debate em inglês, mas antes vou então passar a palavra à Manuela Costa.
Hi, Andrea. Thanks for having me here. It's a pleasure to talk about such an interesting point, and I'm pretty sure that we'll have such positive implications for Portugal and the Iberian markets in the future. A lot of people have heard about third-party funding, but do not know exactly what it is. So put in the simple form, third-party funding involves an entity with no prior interest in the legal dispute that will provide the financing to one of the parties, who is usually the claimant. This financing is offered on a non-recourse basis, which means that the payment for the advance of the capital costs and the return of the capital invested will only occur when the claims proceeds are recovered by the party. Meaning, if during an arbitration or maybe a complex litigation, in the end, the party is not successful and for that instance, will not be able to recover anything from the arbitration, it is the funder who will have to have this risk of receiving zero. But third-party funding is now reaching the Iberian market, but it has actually started in common law jurisdictions. So historically, it started with Australia and then it moved to UK and England. In these jurisdictions, it's now widespread and accepted. And has been able to establish a thriving legal finance markets to which the parties can rely on. So this was actually good because it gave the background so that this practice could expand to further jurisdictions and now has reached, for example, Singapore, Hong Kong, China, Latin America, and Europe, and now the Iberian market. So one of the main questions that I am asked is, why is funding sought and by whom? So I guess we have probably here two kinds of companies. There are the ones that have to use third-party funding and the ones that don't have to but want to. So historically, third-party funding was more conceived for parties that were financially distressed and would not be able to pursue their claims if they would not have a third-party funder who would be able to cover these costs. Meaning, if there was no funder, the claim would just be left out, or the company will have to make a decision of whether to pursue that claim and maybe affect the core business of the company instead of just leaving it aside. Since this practice has evolved, now we can see that a lot of actually financially health companies having been making use of third-party funding. Even if a company now has a budgetary room to fund litigation, for example, it's known that litigation is inherently uncertain, lengthy, and costly. So a party will have to manage the risk of litigation, complex litigation or arbitration for quite some time. So these companies just decided to dilute this risk and bring on a partner, in this case the funder, who will be able to help them reduce legal budgets, take the costs of arbitration and complex litigation off their balance sheets, and allocate these resources to other parts of the company, mainly to develop its core business. And so on, and because of that, it's now widespread for a lot of different segments, and it's not only pursued by companies in financial distress. About the basic structure of a third-party funding, so you usually will have a funder who can be a fund or sometimes an insurance company, but mostly a fund who will provide resources for a claim holder, an entity, and these resources are designed to cover legal fees with lawyers and other costs considered out-of-the-pocket costs, meaning if it's an arbitration, for example, arbitral costs, costs with the administrative costs of an institution, expert costs, and also the costs for the enforcement of an award or a final decision. Because winning the arbitration or a complex litigation is just one part of the game. Then you have to enforce it to be able to actually recover. And depending on your case and the dispute, for example, a complex arbitration, you will have to then enforce these awards in multiple jurisdictions around the world. So maybe France, China, India, and this is costly and will also take time. In either way, we have seen that the recent development of the third-party funding, which is usually done by assessing data of the UK and sometimes US and Australia, where it's more developed, has shown that, for example, in the past 5 years, so around 2014 and 2015 to almost today, the number of the financing markets has upsurged from £500 million pounds to almost £2 billion pounds. This is an impressive increase in the financing, but it does not even show the real picture. That is because third-party funding is most of the times confidential, so we do not have access to all the data available. But we have heard that probably in the UK, this number is already reaching about $10 billion, and worldwide, it's a $70 billion market. So it's pretty interesting for most of the companies. So if a company decides that it wants to pursue third-party funding, it needs to understand a little bit of the process and what is the funder's fundamental criteria for deciding whether or not it's going to invest in a case. So funders do their assessment usually through a two-stage process. So first, they analyze internally the dispute, the claim that has been put forward for them. Most of the funders now have in-house lawyers have their expertise in sectors such as energy, construction, financial markets. And internally, they do the first step and decided whether or not their interest in the claim. They also take in consideration most of the time the value of the claim, which is important to stress here that during the past years, third-party funding in the beginning had a really high threshold, meaning funders would not look at a case unless it was over $20 million, $10 million. They would consider that the investment was not worth it otherwise. This has changed a bit now. We have multiple players in the market and people with much more knowledge of how third-party funding works to assist either the companies or the funders. So now, for example, you can find funders that are willing to invest in disputes over 3 million, for example. But coming back to the criteria, the funder is also going to take a look at the amount that we'll have to advance, the jurisdictional obstacles, meaning if they are going to have to pursue a claim in China, it's probably going to be much harder, and we can have some jurisdictional issues than if we do it in France and in Europe. They also going to probably take a look at the nature and the length of the proceedings, the possibility of settlements, because the amount of the funder is going to recover depends whether the case is going to be settled or not, so whether you are going to reach the final stage and actually receive an award or a final decision. They will also look at the creditworthiness of their clients and their opposing party to know if in the end of the line, they will actually be able to recover anything from their party, if they have the means to pay for the award or for any condemnation that they have. And they will also probably take a look at the law firm that is going to help their claimants in the arbitration or litigation procedure, whether they have the necessary expertise, whether or not they have worked with that type of cases, and so on. Normally, after this first internal phase, if the fund is satisfied and wants to go to pursue the dispute, they will then move into a second phase, that it's a more detailed and a more in-depth assessment that is going to probably be done by an external firm, normally a law firm, but that is going to work for the funder. They would not have anything to do with the claim holder. And this is also, I think it's important to say that it's some different types of litigation financing that these funders offer. There's the most common one, that it's single case funding. That's what we have been discussing here. So I have a case against a party X, and I need financing to cover litigation costs, out-of-the-pocket expenses, and maybe enforcement costs. There's also something now called a portfolio funding. That is to say, mostly law firms or big corporations will build up a portfolio with multiple cases, which will have different levels of risk, and will then become more attracted to funders because they will be able to maybe dilute a bit the risk that they have with the cases that are inside. Also, a lot of companies resort to funding just for the enforcement and asset recovery procedures. So imagine that I'm a company and I went through an arbitration and I won. That was great. And now I have an arbitral award and I need to enforce it. This is also costly. As I said before, you may have to enforce it in different jurisdictions. The company that you are enforcing it against has assets all over the places, and be sure that they will try to fight the enforcement proceedings and might also initiate annulment proceedings. So we are probably going to look here at, I don't know, 1 year, 2 years, it may be even more of hard litigation before state courts to be able to enforce an award or to enforce a final decision from another jurisdiction and be finally able to collect. So a lot of funders, what they do is that they monetize this phase for a company. So they provide upfront liquidity. So you now have your award. I will provide you liquidity, and in exchange for some portion of the final recovery, which I will only receive in the future when we are actually able to recover the proceeds of this case. Third-party funding has also raised a lot of discussion about the triangular relationship that occurs here among funders, law firms, and the clients. The main reason is because a lot people that are against third-party funding, which now not a lot of people, to be honest. The practice is now has gained its roots and has evolved a lot in the recent years, but part of the people are concerned that funders would create and would increase litigation in the jurisdictions, meaning meritless claims that would not go forward will now do it because funders will be able to back them up. Also, a lot of people are concerned the funders will have an active and intense participation in a case and in the process, and may take control over a proceeding, leaving the claim holder a little bit aside. On the side of lawyers and the law firms, the discussions are mainly regarding probably the conflict of interest that may arise. For example, most of the times it's the firms that see potential claims that might interest funders. So to what extent of a law firm that has identified a claim and has presented it to a funder will be impartial enough to conduct the proceedings, the litigation proceedings or the arbitration proceedings in the best, taking its client's best interest and not the funder. And finally, the client that sometimes does not have a lot of knowledge in this matter and might be a little bit dependent on what the funder will decide or what the lawyer will decide. But what we have seen now is that the practice has evolved to create its own best practice, to give more understanding to people of how it works, and to providing more clarity on to what extent the funders will go and how independently the claimant holder will be. And most of the times, funders and claim holders discuss in very detail how the funding agreement will be and set the boundaries to what one other will be able to do in the funding agreement. So that is to say, and probably leading to my final slide, that we used to think that third-party funding was something that a law firm would present to a client and then bring to the funder, and companies would be totally out of the blue regarding this process. Recent research has shown that the common law jurisdictions that have often using third-party funding do not consider that this is the right approach. So it's much more of a collaborative approach. Most of the cases that have been funded have been, the companies have not been decided that on their own, but they have not been imposed by law firms. I mean, most of the times has been a collaborative approach between either the firm and the company, and they have reached the solution that brings clarity to everyone. But also inside the companies itself, this is not a decision that it's left that is left only to the legal department. We can see nowadays that the decision or not to pursue third-party funding is discussed among the pricing departments, the finance departments, the management, and the legal department. And they come up with several solutions and decide whether or not they want to pursue third-party funding and have a partnership with a funder abdicating for a bit of the possible return that they may have in a successful case. So that is to say that third-party funding has come already a long way, but probably will now be able to develop even more and help companies and legal departments to become more commercially minded departments. They are able to use legal finance to create certainty around the litigation costs and to pursue affirmative recoveries without adding expose or risks to the company's balance sheet. And Portugal, it's now ready to enter this race. We only need qualified lawyers because we already are seeing the creation of funders, and funders are now looking at the Iberian market and see the endless possibilities that we also have here. But all these topics are going to be discussed, I believe, in more detail by our speakers today. So I will give the floor back to André.
Thanks very much, Manuela, for your presentation, for giving us this big picture on third-party funding. We'll now go on with our debate, and we'll have, as I said, Miguel Esperança Pina, sócio da CMS Portugal, Luís Andrade Pinhel, General Counsel para Portugal da PLA, Jesus Rodrigo Lavilla, CEO da PLA, Robin Wood, associado sénior da CMS UK, e Manuela Costa, sócio especialista em litigância da CMS. Miguel, I would start by you and by asking you what is the relevance, the added relevance that third-party funding has in a context as we live today, when a serious pandemic brought us to a very deep economic crisis?
Well, first of all, thank you very much, André, to be here. It's a great pleasure to be here with my colleagues, and I also to want to congratulate Manuela for the brilliant exposition that she offered us. Well, going to your question, the economic crisis that we will have for sure will lead to more conflicts. I would say that is a natural consequence of the lack of the financial resources, and also due to that lack of resources, the players, and I would like to stress out that the players, we have the companies, but also individuals, in order to claim their rights in court or in arbitral tribunal, they need to have access to funds to finance such disputes. Funding can be made available by the traditional means, but the third-party funding can have really a special role. First of all, we in the middle of such deep crisis, the current one, unfortunately, the traditional funding may be already taken for other purposes. So we can have a problem there. Secondly, and I would say that is the main aspect, the third-party funding is tailor-made. And especially, well, Manuela has already pointed out, in the dispute, all the risk or part of the risk can be taken by the funder, meaning that the player may not support any costs if he loses. The funder will cover lawyers' fees, tribunal and cost fees, insurance to cover adverse fees, and all kind of costs, translations, expert reports, or legal opinions. So, well, it's really very significant because upfront in the beginning, when you start a dispute, the player can prevent any kind of costs. It's really a very important aspect. As
what kind of
Manuel,
what kind of litigation do you expect to increase, namely in Portugal with the crisis?
Well, according to the previous crisis, the subprime crisis, insolvency disputes were likely to increase in this kind of situation, and I think we will have the same situation. But I believe also that we will have very significant arbitrations, namely regarding the infrastructures disputes and project finance disputes. We had a very significant number of arbitrations with huge amounts. I participated in several, and each arbitration, the amount of the claim was roughly 1 billion. So it was, I think, the first time in the judicial history of Portugal that we had such significant amounts in dispute. So I believe that now we'll have a similar scenario. The question is, well, in the previous crisis, there were no third-party funders acting in Portugal. So the question is that has anything changed since then? I think the answer is yes. Manuel has talked about that. The issues that the problem was that the framework of the requirements of an international third-party funder did not match with the size of the Portuguese market at that time. Usually, the third-party funder threshold is too high, around 40 million or something. And nowadays, things changes, and especially we have now special vehicles and tools, financial tools, to act in the Iberian market, as the PLA is a very important example of that, and the threshold is much lower. We can have access to fund a dispute of around 3 million or 2.5 million. So it's completely different. So I really believe that we will have these two will be a very important tool to develop the litigation in this crisis. And it's very important to think that the third-party funding, not as a tool of the rich man, but with these new limits, I think it will be a very significant tool to the democratization of the justice as significant companies and individuals may have access to finance their own disputes, and if it was not the third-party funding, they wouldn't be able to exceed the justice.
Thanks, Miguel.
Thank you.
Thank you. Passing to Jesus Rodrigo Lavilla. What are the advantages and disadvantages, so the pros and cons for companies and even to the judicial system of going for third-party funding?
Boa tarde a todos. A pesar de a miña pronunciación non ser la mellor, gostaría de usar brevemente a vosa lingua materna para agradecer ao Jornal de Negocios e a CMS o amável convite que fixeran a PLA a través do noso conselleiro geral Luis Andrade Piñel para participar neste programa, dándonos a oportunidade de con todos vos podernos trocar impresoes sobre a nosa actividade de financiamento de litigios. Now I'm going to change into English just to answer your question. I would say that there are a lot of advantages of using litigation funding for a company, and we should start for the main role that the third-party funder is going to play, which is to act as a partner with the company, aligning the risk, aligning the interest with a goal, which is to win, fulfilling all the legal and regulatory requirements, the litigation or the arbitration. For sure, going further, depending on the needs of the client, a company could recognize a contingent asset on its balance sheet, could generate incomes through selling or funding a litigious asset, or could generate liquidity. We could also add that a company could decrease provisions by selling or by selling its litigious assets. Companies will be able to access to better lawyers and better experts because their fees are expensive, and the litigation funds have no objection to pay what they should honestly and truthfully pay, just to be in a position where the interest of its clients is going to be duly support. This could lead us to other place, which is where is the right place to be for a litigation fund. We are speaking about complex litigation and multi-jurisdictional litigation. But as Mr. Miguel Pina said, this should help to democratize the access of justice. For sure, my former commentary with regards to the access of better lawyers leads to a best practice in the industry, because even though the company should have access to better lawyers and to better experts, in every case, the decision in the legal proceedings or in the arbitration proceedings has to be made by the company with its lawyers, with its team of lawyers. So that means that litigation fund fulfilling or following, the best practices is going to do a due diligence when entering into the litigious asset. It's going to follow the litigious assets. For sure, it's going to provide its technical opinion, but the final decision has to be made by the client and by the lawyer. With regards to disadvantages, honestly speaking, I do not see such if you are working with serious market players. But of course, it is true that the presence of a litigation fund is not free, and it is required to obtain a return on a binary and a contingent asset. So the binomy between risk and reward should be duly balanced.
Is there a question here for the judicial system through the risk of increased litigation? Could that be a problem?
Yeah, from our perspective, this is not a real problem, but a theoretical problem due to the fact that a litigation fund is going to deal with institutional investors. So it's going to take into account its own reputational risk. So that means that a litigation fund is going to look for complex litigation with good grounds and with extraordinary costs to be covered. So the consequence of that is that for sure complex litigation could raise, but at the same time, complex litigation with good grounds, because at the end of the story, the litigation fund is going to align its interest with the client's interest, and it's going only to provide funds to complex litigation, for sure with high risk, but with proper grounds. So our view is that specialist funders are not going to help the increase of massive litigation. On the contrary, perhaps you could find other niche in the markets, not for specialist funders, where massive litigation could be increased. But from our perspective, and this is something for the debate, we understand that we are not going to increase any kind of the litigation, but we are going to help to companies to have access to justice in complex litigation with high cost.
Okay, thank you very much, Jesus.
You're welcome.
Robin Wood, hello, good afternoon.
Hi, good afternoon, Andre.
Hi. This model emerged in this Anglo-Saxon world. What resistances it had to overcome, and how is it being used now in more mature countries?
I think it's interesting to look at the Anglo-Saxon world from the Iberian Peninsula and see the progress that third-party funding has made over the last couple of decades. Manuela showed us the slide that had the value of the assets of the third-party funders growing from $500 million to $2 billion over the course of the last 4 or 5 years. In a lot of ways, as we've heard, this isn't really a new principle. Companies have been looking at debtors and creditors as assets and liabilities on their balance sheets for a long time. And they're very accustomed to factoring their invoices, insuring against liabilities. What's new is the application of these principles in the legal sphere. Lawyers, as I think everyone will admit, are quite conservative, and possibly more than most of the English lawyers. And for a couple of 100 years, there's been a doctrine that third parties should not be involved in the direction of litigation. Doctrines that are known as maintenance and champity were prohibitions on third parties getting involved for fear that they would bias the legal system, that they would sponsor litigation for reasons other than finding the truth in the particular case. And for a very long time, the English courts disapproved of this practice and would strike out litigation that was funded by third parties. And little by little, that's relaxed. It started with no-win, no-fee lawyers, success fees where the solicitors would accept either a reduced fee or no fee at all if they were unsuccessful, and a higher fee if they were successful. And there was a fear initially that that would lead to a big increase in litigation. There was talk of particularly personal injury cases. Lawyers were chasing road traffic accidents and that sort of thing, and it was not well received. And the government ran a review headed by a very senior judge called Lord Justice Jackson, who concluded that there was a balance to be struck here. And this is what Miguel was alluding to as well. A balance between access to justice on the one hand, where people who have a good claim but can't afford to take it through the courts should be allowed to access funding to help them do that. On the other hand, you need to balance the interests of people who are being sued to make sure that they're not being pursued vexatiously for reasons other than because there's a good claim. And the conclusion that the review came to was that properly regulated and properly managed third-party funds would do more good than the risks that they would bring with them. And I think that's definitely been the experience in the London market. It started out very cautiously received, but little by little and led by the more sophisticated commercial parties who have the luxury of analyzing these things and assuming the risks properly with shareholder accountability. Slowly, confidence has grown, and there's a real acceptance now that a lot of good cases could not have been brought to court without the help of third-party funds that have been successfully pursued. In the UK, there are codes of practice for the lawyers that govern things like conflicts of interest. And there's a rule that, generally speaking, the third-party fund has to not be the majority beneficiary and can't control the litigation day to day in order for it to be permissible. But these rules are evolving over time, and as the parties and the courts get more comfortable with it, the experience is that third-party funding is more and more not just part of the fabric, but actually a tool that businesses are using like any other risk management to take these liabilities off their balance sheets and manage their risk in a commercial way for the benefit of cash flow and shareholders, in the same way that they do with insurance products and factoring type products and any other financial structuring.
Mm-hmm. So we would say that they prove their value. Luís Andrade Pinhel.
Hello.
We already talked. Hello. Good afternoon. We already talked a little bit about the relationship between clients, funders, and the different law firms that assist each other. How is this process? How is it? Can it be managed, and it is managed in this when we use third-party funding?
Well, first of all, I would like to thank the Jornal de Negócios and CMS for inviting us to this event. It is an honor for us, PLIA, to be able to discuss this issue of litigation funding in this forum. Well, I think, Andre, you were asking me what is the role of law firms in this process, and so I think in relation to your question, I would like to say that law firms play an important role in the litigation finance industry. On the one hand, law firms have to help litigation funds study the various investment positions that they are considering. To that end, on the investment opportunity analysis has been conducted by the litigation fund's in-house team of lawyers. An external team of lawyers should be engaged to analyze the litigation and report on its viability. So, in other words, we are talking about two distinct legal teams working in this matter. So it is very important that the external legal team does not know the conclusion of the report made by the internal legal team. In addition, law firms will handle through their litigation departments the lawsuits and arbitrations in which the litigation funds are invested. In this case, the lawyers will make the decisions with their clients with prejudice of the litigation fund's follow-up of the case. It is very important emphasize that the law firm that carries out the external report cannot, in any case, be in charge of the handling of the lawsuit or the arbitration in order to avoid any type of conflict of interests. This is a very important point.
Is there any communication between the two law firms or never?
No, there is no communication between the two law firms. What is important is in the first phase. Then we will have a second phase. In this second phase, we are talking about parallel legal terms. The client and litigation fund in this second phase will rely on the same counsel. So in this, we are talking about a second phase. Okay. This is without prejudice, once again, to any legal opinions that litigation fund may seek for itself for independent counsel during the process. So we have two phases. The first one, they have no contact. In the second one, the client and the litigation fund will rely on the same counsel. Finally, the law firms are very important also, and the role of the lawyers is very important because the funds need lawyers for the closing of the contracts. And this function is of a great importance for the funds, as they need good legal advice in drawing up the complex contracts that they are going to sign.
Mm-hmm. Thank you, Luis. Manuela, I would go to you just to ask you, because the state is often the target of the claims. Is third-party funding also a good solution in this case?
Yes, it is a good solution for the investor. I mean, a lot of times, cases against the state involve, for example, foreign investors that have participated in concessional agreements and have now business in Portugal, for example, or they deal with SPV companies that have multiple shareholders, which may have enormous claims against the Portuguese state. And in this perspective, depending, for example, how an SPV is financially, it is interesting to bring a funder into the equation and afford an arbitration, for example, against the state. Most of the times, foreign investors, do have the means to fund their own arbitrations and litigations. But as I said early in my presentation, deciding or not to follow a different approach in litigation finance, it can be to the benefits of the company or of the SPV, and to that extent, it's available against also in arbitrations against the state and in litigation against the state.
Mm-hmm. Thanks, Manuela. Miguel Esperança Pina, I'll go back to you. How do you see this third-party funding being applied to the Portuguese market? For instance, well-known aspects as the slowness of the judicial system. Can this be a roadblock or no? Do we have the needed regulatory framework? And what about professional secrecy? These issues can be an obstacle or not? Miguel, we are not hearing you.
Sorry.
Okay, thank you.
Well, there's a lot of questions in your question, but it's true that the size of the Portuguese market, the size of the common deals in Portugal, the slowness of the courts are not really appealing for the third-party funders, for sure. But well, regarding the legal framework and the professional secrecy, I would say that generally in the European space, all the countries have roughly the same problem. So I wouldn't say that is a specific problem for Portugal. But the truth is that it's something new here. We don't have third-party funding in Portugal, so we are starting, and as everything that starts, it's also attractive and appealing, because we have everything to do, and namely, and the example is that we are here. We have a Spanish investor, an English lawyer from CMS UK. So the third-party funding can get together all these resources, and I think it's very important to increase the sophistication of the justice in Portugal. We really need that, and as it is very demanding once the funder is bearing all the risk. I'm sure that we will increase enormously in a huge way the justice, and we will prevent a big part of the problems that we know in Portugal. Talking about advantages, you were asking Jesus if the third-party funding, if it would stimulate more litigation. I think the answer for that question is quite simple. Instead of stimulating litigation, it's not the issue. The issue is that you as Robin and Manuela pointed out, we have a value in the balance sheet of a company, and without litigation, you have always just a value in the balance sheet. With this vehicle, you can litigate and transform a theoretical value in a real asset. So my answer for that question, and I think it's a huge advantage of the third-party funding, is that you will stimulate the economy, and that in another way you wouldn't, because the players wouldn't be able to have access to finance their disputes. So I think it's well, I don't know if you can say that in English, but in Portuguese you usually say it's a question of seeing the glass empty or half empty or half full. And I would say that that's it. You have the tendency, the Portuguese people has the tendency to see the negative aspects of the glass, and here with the third-party funding, it's easier to see the glass half full. The other issue that I would like to stress also is you were asking about the state, if with this tool it's a way to litigate against the state. But I would say that the state and the public companies are a potential client of the third-party funders, because as Manuela was saying, even if you don't need to finance the dispute because you don't have money to, sometimes it's better to finance the dispute with the third-party funder, because instead of use your resources in a risky issue, you can release your resources to invest in your own investments of the core business of the company. So I believe that the Portuguese state and the public companies at a certain time, when they understand this, they will use the third-party funding. I'm sure of this. So
okay.
I think that we have so much opportunities in the Portuguese market and in the Iberian market, because well, Spain, it's a much stronger economy than Portugal, but at the end of the day, we have a similar culture and a similar structure also of the economies.
Okay, so this instrument can help, can even help some companies recovering, because they have that earlier liquidity when they go with third-party funding. Jesus, going back to you, because we also have to talk about the costs of going for the solution. We understand the benefits, but what are, on average, the costs, and what are the factors that influence them? Because if I understand, the costs can vary a lot.
Yeah, thank you very much. It is true, Andre. It is said that in this type of deals and operations, the average cost goes up to 30% of the value of the lawsuit to the company. But for me, when we speak about general figures, we incur mistakes, because we are speaking about an average, but the next question should be, is there a large standard deviation on that average? And I'm afraid that the answer to this second question is yes. And as Miguel Pina was saying before, this is a tailor-made solution. And that means that you have to measure the cost on a case-by-case basis. Per position, we consider at least more than 7 variables in our analysis, of which only one is legal risk. What those variables are depends on each fund, but as you can imagine, country risk, sector risk, trade risk, solvency risk, interest rate risk, and exchange rate risk always need to be considered. Answering your question, we have an average figure. For me, that figure isn't representative, as there is huge standard deviation. We have to consider a case-by-case basis. Note that we accompany Portuguese companies and Spanish companies in an international jurisdiction. So that means that the risk of litigation in one country, for instance, and Azerbaijan, it is not the same as the risk of enforcing a final and definitive judgment against a Portuguese or Spanish public administration. I would not want to get into complex discussions about financial valuation, but I think that companies should bear in mind, if they were to flip a coin and bet on heads or tails every time you flip the coin, I mean, they will be running the risk of losing 50% of the time. That's the risk that the litigation fund is going to run, and that's the risk that the company is going to avoid. So I think that in a nutshell, we have to consider each case as a unique case with a unique financial solution.
Okay, thanks, Jesus. I'll jump to Luís Andrade Pinhel, because I think a follow-up question would be how long does it take, and concerning the due diligence process, how long does it take to know if a third-party funder will be available to fund a claim? What information is needed for the due diligence process? Are there confidentiality issues?
Thank you, Andre, for your questions. Well, we can start for this question. How is the due diligence process? Well, the due diligence process is a standard process in which we replace an industrial asset within the contingent asset for a binary nature, a litigious assets. The average duration is between 8 and 12 weeks, depending on whether or not there are multi-jurisdictional aspects involved in the investment opportunity. What information is needed? I think it was one of your questions also. Well, the external lawyer's report will always be required to cover regulatory issues and also tax issues, procedural issues, and commercial issues. This is in addition to any other issues that may be required on a case-by-case basis. Depending on the type of dispute involved, independent expert reports will be aided also if it is needed. Due diligence requires access to all relevant procedural documentation, as well as all documentation that may exist on the lawsuits. In addition, it is common also for litigation funds to want to talk to the internal departments of the companies. How long does it usually take for a client to know if the third party goes ahead? I think it was other question that you
Yes.
have made. So litigation funds act on a success, so they try to be extremely agile in their decisions. Litigation funds see quickly whether or not the case can or cannot be investable. In such a case, a first favorable answer is given in 7 days, and the internal study of the case begins after that. After 4 weeks, we might say, there should be an indicative offer. We can talk about a non-binding offer. After this, and following the due diligence procedure, there should be a binding offer within a maximum period of 4 weeks. Finally, the transaction is closed and the contracts are signed. That's it.
Okay.
That's it.
And that's the process. Thanks,
That's
Luís.
the process, basically.
Robin Wood, we already talked a little bit this afternoon about the conflicts of interest. What are the main conflicts that may arise? For instance, is our settlement a slippery slope? Because I manage that sometimes the funder would prefer a settlement, but the client maybe he expects he can get a better outcome. And how can these conflicts, these different views, be merged together and the conflicts avoided?
I think this is a very important point, and it raises a very complicated legal point as well, particularly when you're looking at international arbitration or litigation, maybe with multiple legal systems in play. As Luis has said, there are two phases to this. And in the first phase, before the funder is formally involved, the conflict is very, very clear and very apparent. That the lawyers that are analyzing the claim are advising the fund on whether or not it's a claim that's worth investing in, and the lawyers that are advising the person with the claim, the claimant, are obviously advising that person on how to win and how best to prepare their case to win. And they're two different questions. The person with the claim is obviously very interested in getting the case before a judge, whereas the fund really only wants that if it perceives that there's an asset there that's likely to be viable from an investment perspective. But then the parties come together when the contracts are signed and their interests become aligned. Both the fund and the claimant want to win that case. They want to get the best possible financial outcome for that. There are still some potential conflicts, and settlements are one of them. I would put it more broadly. How do you define success? Often it's just about money, but also sometimes you're asking the judge to give orders that don't have a financial value, orders to do something or not do something, that it could be as important as the money to the business that has the claim, but obviously less important to the fund. And I think the key there is just to make it really clear when you enter the agreement with the fund what each party's measure for success is. Total transparency and trust. Treat the fund as a partner, and if everything aligns, they'll invest, and if they don't, then it's probably better for both parties that they didn't anyway, because the interests wouldn't align. But there's an underlying legal point here, particularly where you're in common law jurisdictions, which is privilege, professional secrecy. Parties can be ordered to disclose documents that are prepared for the purposes of their business, but not for the purposes of litigation. And in that first phase, before the fund is properly instructed, all of those due diligence reports that are being prepared, they're being prepared for the commercial purpose of the fund's investment decision, not for the purposes of the ultimate litigation. So you need to be very, very careful. And this is another reason for separating the legal mandates out, to make sure that those documents remain confidential, that the fund is provided only with documents that are either subject to non-disclosure agreements or which can be disclosed safely. And you need to discuss this again in a very transparent manner to make sure that everyone knows what's being handed over and on what basis. But once the fund is engaged, that problem should resolve itself, because you enter into a common interest situation where the fund also has an interest in the litigation. And most common law jurisdictions would see that as being equivalent to the claimant and covered by professional privilege. But it's a very complicated area that needs to be studied, to borrow a phrase from Miguel and others, on a case-by-case basis. It's a made-to-measure solution that needs to be really thought through from the beginning of the process and throughout.
Okay, it has to be a process like the due diligence. This process of analyzing potential conflicts of interest must also accompany all the process. I don't know if any other of our guests wants to comment on this topic of the conflicts of interest.
Well, if I may, I just would like to say that for us as litigation funders,
Jesus, go ahead.
Or for sure other players, the proper management of conflict of interest, it is a must. If you manage improperly a conflict of interest, that means that you are out of the market. And for that purposes, or those purposes, it is extremely important to know what are the best practices in the industry of third-party funding. So, as Robin was saying, there are technical procedures to avoid conflict of interest. For instance, if we were speaking about settlements, we truly think that to avoid a conflict of interest, the different consequences of a settlement should be regulated in the investment agreement. That means that when the settlement scenario starts, the fund has nothing to say, because everything everything has been said before in the investment agreement. So we are absolutely aligned with Robin's views. This is a practice where conflict of interest could come into the arena, and at the same time, conflict of interest should be managed with excellence. Just to conclude, let me say that it is not the only place where you could find conflict of interest. For instance, in capital market practice, when you are working to float a company in a stock exchange primary market, also there are several conflicts of interest. And the point is to deal with those conflicts of interest with excellence.
Okay. Thanks very much, Jesus. I don't know if anyone would like to add anything to our debate before we close. Thank you all for being with us, and we're ending this conference. Thanks very much for watching, and have a nice day. Thank you very much. Resta bom dia. Obrigado.